Just,
I'm sorry, Chief.
not 150 years ago, but I think it's 10 or 12 years ago in city of Fulton, which you cite in your brief. It sort of follows up on Justice Thomas's question, although you don't even get to speech. I think the court in that case said, when you're looking at some of the concerns that you're talking about, that a individualized, subjective, multi-factor whatever determination, in that case foster care and adoption, is not the same as a seat on the bus or a room in the hotel. How does your argument fit with that position that was articulated in the court with respect to the nature of individual speakers' message?
Well, I think those questions are not presented in this case because most artists are not public accommodations, but my friend stipulated that the company was a public accommodation, and often a lot of the hypotheticals that we've been talking about artists, and certainly Lin-Manuel Miranda, who is writing the play Hamilton,
in terms of the concern expressed in a lot of our cases about compelled speech and the distinction of others where you can have a requirement of serving people without regard to certain characteristics. The case did make the point that to the extent there's subjective, individualized determinations that go into the decision about placing children, that those cases were not, at least not directly applicable.
That's correct, Chief Justice Roberts, and I think here, again, the record is entirely devoid of those factors because the company chose to litigate this case as a public accommodation. I think a lot of the description that we heard today would be powerful arguments that they may not be a public accommodation in what they do, but we simply don't have those facts here. But certainly the level of selectivity, the way in which the potential customer engages with the client, with the service provider, and how the service provider makes their product available or known to the public, all factor in that analysis.
I'd like to ask you a question about one other case. It's the one you rely on most heavily in your brief, Rumsfeld against Fair. And it seems to me that a distinction you have to deal with in that case is that the speech there was not compelled, or what was compelled was not considered speech. It involved the schools providing rooms for the military recruiter. And when it came to the question of compelled speech, what the court said is empty rooms don't speak. But here, of course, the whole argument is that the speech is being compelled. So how does the either holding or analysis in Fair help you?
Two responses, Chief Justice. First is, in Fair, recognize that there was some speech by the schools. There were emails, posters on bulletin boards, et cetera. So there was some speech, but it said it was incidental, like in O'Brien, to the purpose of the regulation, which was ensuring equal access, similar to Colorado's law here. And the second point I would make, and it comes from the example of the identical website being turned away for the same-sex couple but provided to the opposite-sex couple. Here, sometimes the speech itself does not change. And what this company seeks, if you look at the specific prayer for relief in the complaint, is a total permission to turn away every same-sex couple, even if they seek exactly the same website that an opposite-sex couple that they would provide.
Just to stop you, their point is they do not turn away same-sex couples who want the service that they're providing. They just won't provide that service with respect to a particular type of wedding.
I respectfully disagree, Your Honor. What the company said is under no circumstances will they provide a wedding website for a same-sex wedding, period.
Correct.
Right, and that is status-based discrimination. And it doesn't matter whose credit card is used for that transaction. What the sole basis that the company seeks relief from this court is they would like an injunction that says, so long as, if this is going to be used for a same-sex wedding, then we need not provide it. And so it's a status-based discrimination that they seek from this court.
I do think the court in Rumsfeld was dealing with the sort of compulsion that is significantly different from the compulsion here. In what other case have we upheld compelling speech? In other words, not simply just restricting speech, but actually compelling an individual to engage in speech contrary to her beliefs?
So I think, Mr. Chief Justice, Rumsfeld really is one of those cases, and I want to emphasize that the law schools there really did have a very credible claim. I think that they deeply opposed the military's policies. And
well, they opposed the military's policies, but all they really had to do was give them an empty room.
Mr. Chief Justice, that's not correct. At pages 60 to 62, the court acknowledges that there were things that the law schools were required to do, like sending emails, coordinating meetings, including announcements in their newsletters, that were clearly speech. The court below had held that
advising people that the military recruiters were available in a particular room, right?
And including their announcements, distributing the announcements on behalf of the military, including the military's announcements in the law school's own newsletter. The court below held, and the law school...
Of the fact that they would be recruiting on campus pursuant to the Solomon Amendment. Do you think that's the same as the speech that's compelled here, which is directly opposite to the beliefs that the Ms. Smith is seeking to convey?
So I think it depends very much about what type of speech we're talking about here. I don't know that it is different in a constitutional sense from the sort of speech that was described in what Justice Kagan, I think, called the basic website, where we're talking about a website that presents in an attractive way the details of the couple's wedding. I think it might be a very different case if she were compelled, if Colorado ever applied its law to compel her to create messages or express religious views about marriage or to do some of the opinion-based statements that Justice Kagan described. But I think that case might well come out differently.
Thank you, counsel. If your client's website, yeah, you go, not so fast.
New way of doing it.
if your client's website was the same as it is, but the only indication of any limitation was a tagline at the end saying these services are for heterosexual couples only, could that constitutionally be applied under the Colorado statute?
The speech could be compelled if you're suggesting that she essentially has a no customers only sign, and that's exactly.
As in your case, no websites. No websites are available except for heterosexual couples.
For marriage?
Yeah, same thing.
Generally speaking, no. In Ms. Smith's particular case, all of her websites are created, they're original, customized to the story. And so in that instance, she believes same-sex marriage to be false and couldn't create the speech.
Okay, what if it said, I won't provide websites for anything other than heterosexual marriages because of religious reasons? Could that be covered? Or is it simply the invocation of religious basis for the objection that protects it from coverage under the statute?
The religious basis is not determinative here. This court has provided broad protection for religious speech, but it wouldn't matter. This compelled speech doctrine applies in a host of situations and cases that are not religious.
I guess I don't understand that answer. In other words, is it simply adding for religious reasons to the label that would change whether it can be regulated or not?
I think what's important is that the objection is to the message she's being asked to create. And so if she believes she's being asked to create a message that violates her convictions, whether those convictions are based on a moral reason or a religious reason, it would be protected.
Okay, thank you, Justice.